Hello, everyone. Welcome to Contract Drafting, Creator Partnership, and Licensing Agreements. I'm Keith Kelly, Chair of the Entertainment Law Section. On behalf of the Beverly Hills Bar Association's Entertainment Law Section, we'd like to thank our generous sponsor, Lawyers Mutual Insurance Company. Please see the chat and written materials for more information about them. I'm delighted to introduce today's speaker, April Paredes. April is the co-owner and principal attorney at Ascent Legal. April practices business and entertainment law with a focus on transactional matters in the entertainment, media, and technology sectors. Her work includes rights acquisition, licensing, and brand collaborations, advising producers, studios, media companies, and major brands entering the content creation space. She handles matters related to the creation, production, and distribution of audiovisual content, including television, feature films, and podcasts. April also works closely with startups, providing legal services throughout their life cycle from formation to exit. Prior to founding Ascent Legal, she practiced at Sheppard Mullin. She also holds a master's in communication management from USC. Now let's get started. Thank you, April.
All right. Hi, everyone. Thank you, Kelly, Keith, for the introduction. So, a large part of my day-to-day work involves helping clients navigate the influencer and content deals, both on the brand side and also on the creator side. So, and seeing where these agreements tend to break down in practice. So, today I'm going to walk through some of the key drafting issues that come up in these agreements and how to approach them in a way that aligns expectations and avoids the common pitfalls. So, before we get into drafting, I want to start off with what actually happens in these deals. So, if we can move on to the next slide. Okay, so these are the common issues that I usually deal with in my practice. So the first one, competitor data. So a creator posts a branded content and then posts a competitor shortly thereafter because exclusivity wasn't really clear in the first place. So that's an issue that I constantly see. Another one is brands' overuse of content. So a brand that takes content and uses it in paid ads indefinitely because usage rights were never clearly defined. So that's another issue that on the brand side it's good, but on the creator side, they're seeing their content being exploited in different types of platforms that they weren't originally agreed to. Then there's FTC issues. So a creator forgets to properly comply with FTC disclosures, and now there's a compliance issue. So oftentimes, depending on how agreements are drafted, whether you're on the uh, creator side or you're on the brand side, it will depend who put that off to the creator and make sure that the creator is compliant. And so that comes into play as well. Another issue that I constantly also see is when campaigns don't go as planned. Let's say a creator is hired by a brand to work in developing a particular video, but then let's say that campaign never comes to fruition. And then what happens next, right? The creator already spent a lot of time developing this video. They have the work product, but then just the campaign's no longer going to be, they're not going to proceed with the campaign after all. So what happens after? So those are like sort of things to look out for, especially when drafting. So here are the key points. So none of these are surprises. Every single one of these issues is preventable through drafting, but most agreements don't address them clearly, and that's where the issue comes in. I had a situation where a brand paid $50,000 for a campaign, and the creator just posted content on behalf of a competitor within that same week. Because the exclusivity clause wasn't clearly defined, it just generally said no competing brands. It didn't have any specificity, which caused issues in the long run. So these are some of the issues that I deal on a daily basis when I'm working on brand deals with creators. So we can move on to the next slide. Why creator deals are different. So these agreements are a little different from your traditional contracts. So they move fast, often faster than they should. And they're usually driven by marketing teams rather than lawyers. So in a traditional production, everything is tightly controlled. The script, the performance, the final edits. In creator deals, it's a bit different. Often the creator is given a product or a general campaign concept, but they're given a lot of leeway of what they can do and how they can present it. So often content creators are referred to as a one-man show. Basically, they get a product, they develop how they're going to present it to an audience, and they have a lot of freedom and flexibility in how they're going to portray that. And by doing that, it makes the content feel more authentic and effective. But it also creates risks if expectations are not clearly defined. So the contract has to do more work up front. So as lawyers representing the creator or sometimes the brand, we have to make sure that everything's specifically defined, it's clearly written, so that way we don't fall into the common traps. And that's why deliverables are so important because they're really the foundation of the agreement. So let's move on to the next slide in terms of what we're actually going to cover in this presentation. So this presentation is not going to be a clause by clause breakdown, but it's going to cover practical drafting tips, common attorney mistakes, and real world issues. And we'll go through 10 key clauses that show up in almost every creator agreement. So let's start with the most common problem. Okay, so where the deals break. Um, so we can go to the next slide. So deliverables. So we're going to start with the foundational piece of deliverables. So everything starts with deliverables. So you need to define what content, right? Whether it's a story, if it's a reel, if it's an in-feed story, is it a video, is it a photo? So that's very important because sometimes, depending on where you're going to be posting and what type of campaign you're running, it's important to make sure that the creator knows what they're expected to deliver, right? It could be a reel, it could be a story that's going to disappear. So everything has to be laid out. Also, which platform is it going to be on TikTok, YouTube, and how many? How many posts do they have to comply with within a week? Is it two posts per week? Is it one post per month? What is the arrangement? And when? How often are they expected to post? So usually when I'm on the creator side, and then I make sure that they understand what are the expectations, right? What do they have to deliver at the end of the agreement? So, but being on the brand side, it's also important in every contract to include the technical specs, if whether raw files are included as part of the deliverables, whether drafts are part of the deliverables as well. So that's really important to be make sure that it's attached as part of the contract. So usually when I'm representing the brand, I make sure that I'm adding exhibits and laying out how long each video is supposed to last, um, if they're supposed to comply with certain specs, what type of creative elements have to be included as well. So that's all part of the agreement. So instead of saying creator will post on Instagram, it sounds very generic. You have to be very specific in terms of creator will publish two Instagram reels and three Instagram stories between, let's say, April 1st and April 7th, right? I've seen brands expect 5 to 6 pieces of content while the creator thought they were only delivering one. That turns into a payment dispute immediately. So from a brand side, specifically, specificity ensures you're getting exactly what you're paying for. From the creator side, it protects against scope creep. which is a real thing, and it's something that creators struggle a lot with. And they end up doing a lot of different content and doing a lot of different additional work that wasn't bargained for in the beginning. So even if you define deliverables, then there's another trap as well. So you also have to look at the platforms, which is covered in the next slide. So platforms. So for example, an Instagram story, a TikTok video, and a YouTube video post all function very differently. So an Instagram story disappears quickly. A TikTok video can continue to circulate, and a YouTube video has a much larger lifespan. They also have different levels of effort and production value and different value to the brand. So what do you actually draft, right? So you have to specify the exact type of platform. So if the content's just going to be living on Instagram, then make sure you're establishing that type of platform. It clearly says in the contract what type of platform the creator is responsible for utilizing in order to present that content. Are they going to be using their own personal handle? Or sometimes creators tend to have their own personal one. And if they're developing, let's say, merchandise and they're collaborating with another brand, then they'll use their own business one. So which handle will they be attaching to each of their content, right? Also addressing cross-posting. So this is something that has been a real issue too. So let's say a content creator develops a video, and then the agreement is just for publishing it on Instagram. But then it has a lot of great results, a great audience. So then the brand decides to use that same video and use it on YouTube or use it on TikTok. But that was not originally the agreement. And sometimes brands will do that. And then as a result, the creators are left with compensation that they should have actually gotten more compensation out of it because they're using different platforms. They're utilizing their posts to gain audiences on different types of platforms. So let's say a brand pays for TikTok content and then reposts it on YouTube ads. That's a completely different value, and it should have been negotiated for upfront. So from the brand's perspective, they're just maximizing the content, right? But from the creator's perspective, that's completely different use and often a much higher value use. So if that wasn't negotiated upfront, you now have a dispute. So that's why it's very important when you are drafting these type of contracts, depending on which side, that you acknowledge the platforms that will be being utilized, right? And then how long will the content live on there? So let me show you what this actually looks like in practice if we go on to the next slide. So what you're seeing here is just a sample deliverables clause. This is how we translate all of those concepts into actual drafting language. And there are a few things I want to point out. So first, notice how structured this is. We're separating deliverables by type, photographs, in-feed videos, stories. That matters because each of these has different type of effort, different value, and different expectations. Second, look at the level of specificity. We're defining the number of deliverables, the format, the platform, and even the duration requirements. So instead of saying just this creator will post on content on social media, we're saying exactly what content, exactly where, and exactly how long it needs to live. And might sound explanatory, but it actually triggers a lot of issues, and that's the cause of poor drafting. So this is, from a legal perspective, this is something that is very important. So this clause defining the scope of performance means you can determine if there's a breach, you can determine if payment is owed, and you can avoid scope disputes entirely. So one thing I want to highlight specifically is this language around pinning content, which is on 3.3, the last sentence. And on Instagram, creators shall pin the stories video on the profile. So that's a great example of how detailed these agreements can get, because pinning does increase visibility, extends the life of the content, and increases value to the brand. But it also imposes another obligation on the creator. So again, if you don't specify it, you can't really enforce it. So that's why it's a good example of how specific, how granular you have to be to make sure that everything's accounted for, especially when content creators are developing content, they're going to launch it in connection with a specific campaign. You don't want to be stuck in these disputes. You want to be able to make sure that it flies smoothly, and that goes back to how drafting the contract was drafted. So let's go to tip number 3 in the next slide. So duration. So is it perpetual or is it time limited? Does it need to stay pinned as we talked in the previous slide? So from the brand's perspective, the longer the content stays live, the more exposure and return they're going to get on a particular campaign. From the creator's perspective, longer duration means a longer ongoing obligation and potentially limiting their ability to refresh their content or work with other brands. So this is where alignment really matters. So if a brand expects content to stay up indefinitely, then but the creator assumes that they can take it down, let's say after a few weeks of promoting it, that's not just a misunderstanding, that's a breach question. So the contract needs to answer it clearly. You also want to think about things like pinning, right? That we've talked about, because requiring a post to be pinned requires visibility and adds value to the brand. But it also affects how the creator curates their profile. So again, that needs to be explicitly negotiated and defined. So duration isn't just a timing issue, it's more a value and control issue. So if you don't define it clearly, it leaves both sides exposed, because the creator might take it down and might be willing to work with other types of brands, and then the brand that they initially engaged with will be exposed, right? So that's why it's so important to ensure to draft language in the agreement in terms of how long is this content going to last? Is there a time limit? Is it sometimes what creators will do when they engage in a brand deal is they've been hired to develop videos in anticipation of a product launch. And let's say there's no duration, there's no time limits, then they might not even go in accordance to schedule. And maybe that promotion that the creator had to present in the first place, they're not going to be able to do so because it wasn't clearly defined in the first place. And that would be very impactful for the brand that's going to launch this product and hired this creator to develop these videos in anticipation of this launch. So that's something to always think about as well. That's why explicitly mentioning duration is very important. So if we can move on to tip number 4, approval. So the approval section. At what point the creator can post whatever they believe satisfies the agreement? And the brand has very limited ability to intervene before it goes live. So approval isn't just a preference, right? Approval is a sort of control mechanism, because the last thing the brand wants to do is hire a content creator to develop a reel on TikTok and have it go live before they actually approved it, approved the quality, approved the sound, made sure that the product is being shown, displayed appropriately with the language that they intend to use it to capture their audience, right? But like most things in these agreements, it needs structure. What should you include? So as as the brand, you want to make sure that you have a clear pre-approval requirement before creator goes out and posts this content. You want to make sure that it aligns with what they were supposed to do in the first place. There's a lot of like representing the brand. There's a lot of content creators that will present their videos, but it's poor quality. The product isn't even shown how it should be. It's not going to appeal to the audience that they're intended to market. So imagine being the brand and not having any type of approval process. That would be detrimental. So that's why it's very important to have a clear pre-approval requirement before the creator can actually post. A cap on revision rounds. So this is more favorably for the creator because typically it is recommended that the creator just revises the content typically once or twice. But what brands tend to do is ask them for unlimited revisions. And from the brand's perspective, that creates a lot of flexibility on their part. But from the creator's perspective, um, creators don't want to work for free. They want a clear cap on revision rounds. So one or two is usually standard, and they want to make sure that they're not basically brands are not nitpicking every little thing, and then they go back and then they're doing a lot of work for free. It's also important to define turnaround times for feedback. So, if there's a video that needs to be approved by the brand, making sure that the brand has X amount of days to get back to the creator so they can make the necessary edits and then they can move forward with revising the video. Now, depending on who you represent, the clauses are going to be able to look very differently, right? As I mentioned, pre-approval requirements are generally more favorable for the brands. They create more flexibility. If there's no cap on revisions, that's great. That's better for the brand, and it gives the brand a tighter control on what ultimately gets posted. So from a creator perspective, though, you want time limits. You want to make sure that you're a clear cap on revision rounds and define timelines so that way the brand can't delay the process indefinitely. So let's take one of my scenarios that I had to work with. If you don't include a revision cap, brands will constantly keep continuing requesting like edits until the content matches their exact vision. I've had this several times because creators enter into these brand deals with no revision cap, and so now they're working unlimited. They're investing a lot of unlimited time for unpaid work, and that's where disputes start because sometimes they'll develop a video. It was in accordance with the specs the brand provided, but let's say the brand decided to move in a slightly different direction. And now they're coming back to the creator and they're saying, "Oh, can you make this edit? Can you tighten this? Can you add something else?" And so that just becomes, a constant struggle with the creator and the brand because now they have to try to align with their vision, which wasn't what they envisioned in the first place. So that creates a lot of unnecessarily frustration on behalf of the creator. So it's best to have everything delineated in the agreement. That way, um, the brands don't have the upper hand in terms of what revisions they have to, endless revisions and so forth. And we can go to the next slide, slide number 5, in terms of tip number 5, payment. So payment terms are not just financial, they're risk allocations. So at minimum, you want to make sure when will payment be triggered, whether payment is tied to performance metrics, whether there are kill fees and it's canceled. So oftentimes it will be hired to develop content for a particular campaign, and that campaign unfortunately doesn't come out, right? It's part of it's just in the works. It never sees the light, and basically they're left with their content. Is the creator going to be compensated for the work they've done already? Or given that the campaign has been canceled, will are they still able to get some sort of compensation? So those are questions that usually get triggered when you're drafting because you have to think about these things. If my client, let's say, was a content creator, they spent a lot of time, effort developing this video or photo, right? They should be compensated for the work they've done, even though the campaign never comes to fruition. So now, depending on who you represent, this clause is going to look differently. From a brand favorable perspective, you want payment tied to milestones, right? For example, X amount upon delivery, or and then X amount upon approval, or and then the final amount upon posting the content. You might also want to tie compensation to performance metrics like views or engagement. But from a creator favorable perspective, you want guaranteed payment. Content creators are now they've made their livelihood off of posting content and making videos, and that's their full-time job. So for them, it's not going to be favorable to enter into a brand deal in developing content and not getting paid for it just because a campaign never took effect or was canceled, right? So from a creators council, you want to make sure that payment is guaranteed, often triggered upon signing or upon delivery, and you want protection for your client in case the campaign doesn't move forward. Let's say it was canceled. You still want to ensure that your client, the content creator, is compensated. Because the worst thing that can happen is that the creator has already created the content, but the brand decides to cancel the campaign before posting. And if there's no kill fee provision, then the creator is going to expect to be paid in full because they've done the work, but the brand expects to pay nothing because the content was never published. So that's not necessarily a negotiation issue as I see it, but more of a drafting failure. And it often can escalate quickly into a dispute. So let's see if we can move to the next slide, and then we'll take a look at how payment clauses are often drafted in practice. So at first glance, this type of provision looks fine, right? The influencer gets paid a fixed fee, they invoice the company, and the payment is due within 30 days. Very standard. From a brand perspective, this is great. Payments conditioned on the influencer satisfying all obligations, which gives the brand flexibility to withhold or delay payment if there are any type of issues. But from a creator perspective, there's no protection if that campaign is canceled. So it's what I was speaking about in the previous slide. Let's say the campaign doesn't doesn't perform well, is canceled, or it's not what the brand expected, right? So the creator could complete all the work and still be waiting on payment. So these are type of the disputes that typically arise when contracts are not clearly fleshed out, they're not clearly drafted, and problems like these arise. They don't arise right now, but after the work is completed, that's when you see the real issues. So we can turn to the next slide, tip 6 regarding scope. So scope creep is a real thing. It's something that content creators always like struggle with, especially when they're engaging with brand deals. Scope is where most of the deals quietly break down because it's not just about the main deliverables, it's about everything surrounding them. So you want to think about additional deliverables, appearances, or events, reposting, or engagement requirements, because these are often requested after the agreement is signed. For example, a brand might say, can you just attend an event? You are creating content for our makeup brand, and we're having a PR event. Can you be part of that? Since you have a lot of followers, it would be great. It would be great publicity. Or can you do one extra post, right? That's a common one that I often get on behalf of clients that are content creators. Can you do just this extra one? It was a great hit, but it would be great if you can do something similar, not necessarily a new type of concept. It's just something, similar to the one that you did, and then we could just post it on your Instagram. But that was not in the contract. And so once you as a creator, you start acting and being willing to make a specific edit or make another video or appear in a publicity event, then brands keep on extending the scope, right, of what you were originally engaged for in the first place. So now you're left having a disagreement. Was that included in the contract or is that extra, right? So every additional obligation should be clearly defined and priced. So that's something that has to be negotiated upfront and included in the contract. Because if it's not defined, it becomes expected. And if it's not priced, then it becomes a dispute later on. So that is a constant struggle for creators with brands because brands want to extend the scope of what the original engagement was. And then that's where you go down a rabbit hole in doing one publicity event and then doing another post and so forth. So let's go on to the next slide and see how an example of how scope can be expanded beyond content. So this clause requires that the influencer to attend in-person promotional appearances. At first glance, this might seem minor, but this actually is a significant additional obligation on top of what they've already been engaged to perform. So from a brand perspective, it is absolutely valuable, right? They're getting extra publicity, they're getting more exposure, more access to the creator, and more ways to leverage the partnership. But from a creator's perspective, this is much a heavier lift, right? And if this isn't clearly scoped and compensated, this is where disputes can really start. So compensation should be tied to these type of appearances. Then you have to go into the weeds, right? Travel, is the creator going to be compensated for travel? Or are there any type of time limits? Are they supposed to show up for the entire publicity event? So there's also scheduling parameters that have to be negotiated in advance and incorporated in a contract. So lots of these type of details have to be negotiated, talked about, discussed previously, because then you go into the issues, right, of whether or not this is going to be compensated by the brand or not. The brand would like it is in the brand's best interest to leave these things a little bit more open, right, in some respects, because then they can just have the creator perform these additional obligations with not necessarily additional compensation. So it just depends what side you are on, but it's very important to think about these things and incorporate them in the contract beforehand, because you never know with content creation, there might be a nice video that gained a lot of traction and made a lot of they made a lot of reshares by different people, right? And then it gained a lot of audience members. And then that might evolve into something else. So it's always good to think about it with those things in mind. And as transactional attorneys, our job is to think ahead, right? We're always thinking about issues that can arise. And so incorporating those skills into these type of contracts, it's going to be helpful in preventing disputes in the long run. So if we could go to tip number 7 on the next slide. So usage rights, how the brand can use the content. So who can use it? Is it only that brand? Sometimes brands have different types of subsidiaries. And so it's important to ensure as a brand that it's not just for depending, right? Depending on how you want to use it, but maybe it's going to be that type of video is going to be applicable to the other types of subsidiaries that you have in connection with your brand, or if you have other type of brands that you like L'Oreal. L'Oreal is a big brand, and so they have different types of products. So can they use it for other types of products as well? That video, if it's relevant. So those are things to think about. For what purpose can they use the content? Whether paid ads are included or not. The duration of those rights. Is it indefinitely? Basically, who's going to own the content at the end, right? From a brand perspective, they want the broad usage rights, the ability to repurpose content across different platforms, because that is cost effective, efficient, and especially if they want to use it to promote different types of products, right? It's going to be very beneficial for the brand. For a creator's perspective, this is where they need to be a bit careful because broader usage rights means more exposure for the brand, but also more commercial exploitation of their likeness, right? And that should definitely come at a higher price. So a brand, let's say a brand takes a creator's content and runs it as paid ads for a year. But if the contract doesn't distinguish between content and usage rights, the brand may be getting the value essentially for free. So those things need to be priced separately. So it is very important to make sure that it is very clear as to who owns it, who can use it, who owns it, what's the purpose for it, whether paid ads are included or not, because those are types of issues that, as attorneys on either side, we tend to um, wrestle with. So it is very important that those are clearly upfront, negotiated in advance, and make sure that you're taking into account and foreseeing these kind of things. So if we can go to tip number 8, exclusivity. So exclusivity clauses are one of the most common sources of disputes in creator agreements. And the reason is they're almost always drafted too broadly. So how do you fix that, right? So it's very important to name the specific type of competitors, if possible, clearly defining the category and setting a diff for a beauty brand, right? Are they only going to be hired to create content on a particular makeup brand, or does beauty, like if they're hired to promote this beauty brand, encompass all the products that this beauty brand carries, right? Because in makeup, there's so many different things. They can do content for eyeshadow, actually foundation, mascara, all these different things, right? So you want to make sure as content creator to ensure like what are you um, being asked to develop, right? What kind of products? And as the brand, making sure that they know you're protecting your brand, right? Because you wouldn't want to hire a content creator to do promotional content for a particular type of foundation, and then you see them promoting another competitor, right? So it is very important to make sure that you get really granular. If your agreement just says creator may not work with competing brands, what does that actually mean, right? Does it mean the exact same product, the broader category, like all cosmetics or anything remotely related? But from a brand perspective, they want broad exclusivity to fully protect their investment in the campaign. So it is from a brand, you would want to think of it about it more broadly, right? and to ensure that the creator that you've chosen to promote the products within your campaign to not take part in competing advertising efforts. So it is very important for that. But from a creator's perspective, the kind of language can restrict a significant portion of their livelihood. Remember, content creators do this for a living. They have replaced their full-time jobs with creating content and videos and photos and all these different things. So if you restrict a content creator from doing any type of promotional content for a cosmetics line, and that's what they're known for, then you've kind of eliminated their availability to partake in other campaigns for other brands. So, as counsel for creators, then you would have to really try to negotiate, okay, what does it mean, right? Competing competitors or a competing industry or things like that, and make sure that you're protecting your creator in the long run. So, and that's where the issue really arises. So not necessarily from bad faith, I would say, but from different interpretations of the same clause. Let's take a look at an example on the next slide. So this is a clause, an exclusivity clause. So here's how an exclusivity clause is seen in practice and compared to what we discussed earlier. Open-ended. The agreement is identifying the restricted parties directly. So from a brand perspective, this is helpful. It creates a clear enforceable boundaries around who the content creator can work with. But from a creator's perspective, this is much more workable than a broad restriction, right? Because they know exactly what's off limits and everything else is fair game. So very clearly defined. If they're engaging with a cosmetics brand and they're just hired to develop content related to foundation, then that's basically it. And so it kind of delineates what content they can and cannot create. And also what kind of different, because sometimes creators might just focus on one type of line of promoting type of content, and then other creators have added more variety to their content creation. So they don't only focus on makeup, but they focus on, let's say, working out and health and fitness and different types of areas, right? So then let's say you have a brand that is all in the health and fitness industry. So they develop workout clothes, supplements, things like that. Then and you just hired this content creator just to promote the workout gear and do promotional content for their end, right? So those are things that if you're hiring one content creator to do a specific work for your particular business, right? But then your business has different avenues, then they sell different products, different merchandise. How are you going to distinguish between those? And how are you going to restrict a creator from engaging in promoting a particular type of products, supplements, or whatnot. So it's very useful as a brand to also think about those things and making sure that um, even though the creator is known for a particular area, they're not going to be promoting competitors that might not sort of align to what you're doing as well, but it's best that there's a clear distinction between the two. So let's go to tip number 9, takedown. So takedown clauses are really about crisis control, right? So they're not heavily negotiated until something actually goes wrong. So what do you need to define? Who has the right to request a removal? How quickly must the creator respond? And who bears the liability if the content stays up? So because timing is everything in these situations. So a creator becomes controversial. Let's say they become controversial overnight. So with these creators, they're like engaging in so many different things. And let's say it's not a good image for your particular brand, right? You hired them to develop content promoting this product that you're about to launch, and it turns out they've they're engaging in other content that you did not know, right? They either have an OnlyFans account or they've engaging in other types of activities that it creates a bad reputation to be associated with your brand. So now the brand needs that content taken down immediately, right? So if your agreement doesn't address this, you're negotiating in real time during a PR crisis, essentially. So, which is the worst possible moment to be negotiating anything. So, from a brand perspective, they want broad, immediate takedown rights with short response windows, sometimes 24 hours or less. So, that's favorable for the brand. From a creator's perspective, creators want time limits. For example, ensuring takedown requests are reasonable, that they're not being asked to remove content arbitrarily. They will also want to promote like clarity around it. Who is responsible if something goes wrong after posting? So those are some things to to think about. Who is going to be responsible to take down a particular ad? Are you going to also have, as the brand, are you going to be able to have access to that content creator's account and take it down, or do you have to wait on them? Do you include a morality clause tied to a takedown? Does the brand have unilateral removal rights, or is there a standard that must be met? So those are the questions that need to be asked while drafting this type of section. As a few key takeaways, I would say that takedown clauses aren't just operational, they're about allocating reputational risk, right? And if you don't define them clearly, you're leaving both sides exposed at the exact moment where risk is the highest. So it is very important to also ensure that thinking about from the brand's perspective, right? Thinking about how you want your product being associated when you're engaging with these content creators. Because I've had clients on the brand side that specifically do not want content creators engaging in OnlyFans. They do not want that. So ensuring that they're not going to engage in that type of work, it has to be delineated in the contract. And if they decide to down the line open an OnlyFans account and engage in that type of activity, then basically, they're in breach of their agreement, and then the content they have the right to take down the content that they've promoted previously. So things like that are also very important to make sure that as the brand, you're still promoting your brand. You're making sure that it is not going to be associated with activities that your company, your brand is not part of, right? You don't want to be associated with those things in the case of the brand. But in the case of the content creator, you still want to have control, right? Even though these content creators are developing content on behalf of brands, they still want to be able to have control as they have control with the editing, with the filming, with the vision of the campaign. In the creative space, they also want to have some sort of control in terms of taking down, removing posts in case, something goes down. So that is also something to look for as well and think about before going through the contract drafting. So let's go to the next slide in terms of boilerplate terms. So boilerplate terms, terms and conditions. This is where sophisticated deals tend to fall apart because these are provisions people tend to skim. especially content creators, uh, if they're representing themselves, right? There's a lot of terms and conditions that they just skim over. But though they're often the ones that control what happens when things go wrong. So when you're reviewing these agreements, there are a few areas you really want to focus on. So, incorporating the terms like the platform's terms of service. So, sometimes in these boilerplate terms, oftentimes there will be incorporation of different platforms, the terms of service of, let's say, TikTok or Instagram or other types of platforms, right? Incorporated in there. So, that's really important to piece out and really take the time to assess what is actually included in the terms and conditions, right? Also, there's indemnification and limitation of liability, reps and warranties, right? And ownership of the content, which is huge. Um, and it's huge because you want to make sure who owns the content at the end, right? Um, and is it the brand itself? Is it creator? Was the creator just hired, assessed, and actually you have to read through the terms and conditions of the agreement and make sure at the end who owns the content, right? But many agreements are structured as work for hire or full assignments to the brand, and sometimes they're it's pretty much it's either work for hire or the creator assigns it to the brand. And also it covers disputes, right, over who can reuse the content. As we mentioned earlier, right, who can reuse the content, who has those usage rights is very important, who can license it, and what the can use it for their own portfolio too. And many of these agreements, especially in the conditions piece, and most people think it's just boilerplate.
Hi, April. Could
I
you repeat
mentioned
the last sentence or
really
start over
take
with the last
um,
sentence?
oh, did I freeze
Yeah, it
at
looks
the
like
end or
the connection is kind of
yeah, so
like
I was talking about the standard terms and conditions. Yeah. Okay. Can you hear me now?
it looks like it's stabilized a bit. If you could just repeat that point again, just to make sure so that we can get
Okay,
a
so
better train of your thought.
yeah, of course. So I was talking about like the terms and conditions is it's really important to piece them out because sometimes, as I mentioned, it incorporates platform rules, and it's very important that the creator knows if you're on a creators council to know what they're actually agreeing to because it might not just be, the standard terms standards terms and conditions that are typical in an agreement, but it might be that there's TikTok's platform rules embedded in there, right? And so now the content creator is responsible for that as well. So it's very important to understand what they're agreeing to. And in terms of the brand, it's really important that the terms of conditions include ownership, right? Because as a brand, you want to be able to own the content. You don't want to be licensing content from the creator. You want to make sure that either they're doing work or hire agreements with the brand, or they're assigning the content rights over to you. And so that way you can use it as as you place moving forward. So then that's really important. Also, termination rights, right? A lot of what happens with brands hiring on content creators is what I've seen is that content creators get really excited to get their first brand deal, and then they start receiving a lot of merchandise, clothes, cosmetics, etc. And then they decide not to continue with the development of promoting the brand, right? They stop doing the haul videos, the Instagram reels, things like that. And so very important as a brand that you're also putting how can you terminate them, right? And if there's something that they have to give back, they have to reimburse, things like that. Just to protect the brand and making sure that content creators are not just at first creating content just to get the merchandise and all these things, right? But are actually complying with what they were hired to do. So that's really important. So those are the 10 tips of content creation and drafting. And those are the typical points and that you will see in sections within an agreement that are heavily negotiated and are pretty the standard structure of a contract brand deal between a creator and a brand. So please let me know if you have any questions. I'm opening it up for questions. We only have around 3 minutes left, but happy to answer any questions that you've encountered as you've been engaging in these deals.
Alrighty, April. So it actually looks like we have quite a few questions in the Q&A right now. So it looks like Joey is asking, when the deal includes paid
Oh, I
usage
can
of
hear you. You're
content.
cutting in and out.
Okay. Um, Joey is asking, when the deal includes paid
Yeah, I
usage
hear a
of the
little bit of it. You're Uh, do you mind putting in the chat? Because I hear you on my
Okay.
end.
Yeah, so it's here. It's within the Q&A feature. Just one second.
Okay, so when the deal includes paid usage of the content from the, do you cap or limit the ad spend? What is the industry standard here? Includes paid usage. So usually with paid advertising, what I've seen from my the deals that I've created is that brands will usually limit the type of spend per ad, and so they'll make sure that there's certain like parameters in terms of like the cap, so that way they're not using most of like the budget for that particular campaign. So, in terms of how I've seen brands navigate this is, yeah, they usually will put a cap on it, and to ensure that their ads are being efficiently utilized. There's because each ad is very costly for brands, so that's how they usually tend to um, do it. So I have another question. So even in the absence of the kill fee provision, wouldn't the covenant of good faith and fair dealing still require payment if the creator completes the work and only fails to publish because the it's mind? This reminds me of the situation when an employer fails to pay a commission because the work is no longer employed because the employer laid the worker off. Thoughts? Yes. So what I've seen with, depending on the brand, but that's been like a constant struggle with content creators, right? Um, being not being paid by doing the work, right? And so that's why we've been focusing a lot on, as counsel for creators, making sure that there's actually a kill fee involved. Because what happens is that payment is usually not guaranteed. And so unless, like, so it's different ways of also structuring payment too. So what I usually do with my, when I'm representing a content creator is I make sure that payment is guaranteed upon delivery, right? Because I want to ensure that they get paid regardless of if the campaign if the campaign actually came to fruition or not. So that's really important. So that's why it's usually that I put that language in there. But I've run into other attorneys that have dealt with creators not getting compensated at all. And so that's why it's really recommended to at least put a kill fee, because they might be working in developing this video. They've completed X amount of time, right, in developing. It's not completed yet, but they've spent a lot of time, and then let's say they pull the plug on the campaign, right? So then they should be compensated for at least part of the work that they've delivered or invested their time in. So that's why it's very important to have that type of kill fee provision in there. Feel free to send me other kind of questions. I'm happy to discuss this individually as well. If you have any other types of questions, or if I could share some insight in terms of like bullet point outlines of what I typically see in addition to this presentation, I'm happy to serve as a resource. So this concludes my presentation with the Beverly Hills Bar Association. So yes, happy to answer any questions after this. Just feel free to contact me.